a production of the New Jersey Courts.
All right, so continuing with your time in the appellate division, you became a presiding judge in 1995.
Right.
Does that change the job for you?
The only real change in the job is that you have to really look at the at the cases quickly at the beginning in order to determine if they're going to be 2-judge or 3-judge cases and who on the panel is going to be assigned. That's the real difference. And then, of course, the presiding judge assigns the opinions for writing. But the appellate division, I think I said to you before, we had to write at least 4 opinions a week during my tenure on that court. And therefore, there was no room for perseverating over things. You needed to be a type A personality, and you needed to get to the work immediately after the oral arguments. And disposition, speedy disposition, was actually a particular value in the appellate division. And that is really less so in the Supreme Court.
And you know, how do you develop your approach to opinion writing? Do you have a particular philosophy regarding it, that sort of thing?
Well, I do. I believe that it's really important that the opinion is not, and I think some scholar once said this, is not just a single ticket for a ride on the train. It needs to have value beyond that. It's not, now less so in the appellate division because you're moving such a huge number of cases. But for Supreme Court opinions, they really need to be teaching devices. They need to explain procedures so that the public and lawyers can order their lives. They can't do that if you're just going to dash something off and say, well, you win and you lose. And so I think explication is a really important part of opinion writing. I think history is an important part of opinion writing. Where did this come from? Where did this principle come from? What kinds of cases did it develop in? And are we actually applying it as we should be, given the history of the term? So.
Now, was there a high turnover in the judges that you would work with, or?
In the appellate division?
Yes, yeah.
Well, yeah, it changed. Every year you were on a different panel.
Okay.
So I was there 15 years, and I sat then with 45 judges as my side judges during those periods.
Wow.
Oh, and they were just great. I'm still friendly with all of them.
And again, we keep coming back to this question, but did you, the number of women in that group of 45, did that increase over time?
Oh gosh, I'm trying to think. When I came on, there was only one woman on ahead of me. No, 2. Sylvia Pressler and Julia Ashby, then me. And that was it for a couple of years. And but at that time, that was 3 out of, say, 24. Now there's like 32 on the appellate division. I believe there are 32. And there's just a huge number of women at this point.
So we come up to 2000. When do you first learn that you are potentially in
99.
contention?
99, okay. The Attorney General and Governor's Counsel, John Farmer, came over to speak to me out of the blue and said that I was in the hopper for this. And this was on a Thursday, and then I got a call that I would meet the governor on Friday morning at Morven. So I had to go over for that. I had a great meeting with her, and after it was over, she said, stick around over the weekend in case I need to reach you. Okay, so I can tell you that my cabinets were never cleaner, than that weekend. My towels were color coordinated because there was no way that I was going to leave that house over the weekend, no matter what. And I didn't hear. So by Sunday night, I think it was Sunday night, I kind of had given up the ghost. I thought, well, somebody else got it, because I thought she was going to call me. But she called on Monday morning, I believe it was a Monday morning, and said, I'm going to make the announcement tomorrow at 10 o'clock. And that was that. I was totally flabbergasted by this whole state of affairs. Honestly, it never occurred to me that I would be in the pack even for that kind of an appointment. So it was pretty exciting.
And do you remember like the press conference, any of that
I
type
do.
of stuff?
And I do. And the real thing about the press conference that I remember is what I said. And it was the truth, and it remains the truth. And that is this. I never had a job I didn't like in the judiciary, ever. I never had a day that I wasn't happy being a judge. I loved the people that I worked with. I respected them, and that being named to the Supreme Court, that was the gift. And being named to the Supreme Court was just the icing on the cake. And that is how I feel to this day. Not that I didn't adore the Supreme Court, I did. But I had, imagine the luck of having a career in which you are excited to get out of bed every day and go to work. That's how I felt about everything I did as a judge.
And what about the process of going through and meeting with the Judiciary Committee and preparing for your appearance?
Well, I had to meet, I went to the office of each of the senators on the Judiciary Committee, and they asked me various questions. But honestly, that first run-through was a love fest. There was no, there was nothing other, except for one senator who didn't like an opinion that I had written in the appellate division. He said a couple of things, but generally everybody was affirmative. It was a quick run-through, which is not what happened on my reappointment, because by that time they had 7 years of my opinions on the Supreme Court to perseverate over, and that was a much more contentious hearing. But all's well that ends well.
And what about your swearing-in ceremony? What stands out about that?
Oh, it was, my mother was 90 years old, and she was there. All my friends, all my colleagues on the appellate division were all on stage. It was just a really warm and wonderful event. That's the only way I can describe it.
And so, you know, we've talked about the incredible workload. Was that something you knew about beforehand, or had
No,
any
I
inkling?
said, when I said, when I
Yeah.
heard that Justice Handler wrote 240 opinions in
Yes,
20
yeah.
years, nothing. I thought it was going to be nothing.
Yeah.
But again, I didn't really take account of the, and you know, maybe I could hit the ground running because I'd written 2,000 opinions. So I was not going to have trouble with the opinion writing aspect of this job. But I didn't realize how many cert petitions had to be reviewed, how many rules and regulations had to be enacted, how many lawyer discipline cases there were. And I also have to say that satisfying 7 people with an opinion you write is a lot harder than satisfying 2 others, or else just writing anything you darn well please, which is what you do in the trial court. You're the master of of all you survey. It was hard getting consensus very often, and it took a lot of time. But it was just an amazing, fascinating experience, and the people themselves, the justices that I sat with, were smart people of goodwill, trying to do their very best for our fellow citizens, just trying to agree. It was just a wonderful experience, that's all I can say.
And did you do anything like observe the court before you went on it, or
No.
anything else to prepare?
No. Not only did I not observe it, I was really kind of floored the very first day because the justices were called upon by the chief to do a full recitation of cases. That she called upon them randomly. And I hadn't prepared anything like that. I read all the cases, but I didn't do an outline so that I could explain them to the rest of the courts.
So which session was that? 2000 or 99?
That would be 99 September session.
Okay, all right. Well, it wouldn't be long before you got into some really big cases, and we want to try to approach this in terms of subject area.
Okay.
So the first subject area I wanted to talk about kind of deals with family law.
Yeah.
And the, let me get the letters right.
VC
VC versus
M.J.B.
M.J.B. case.
Yeah.
Any memories of that case in particular, or like that subject matter in general?
Yeah, it was a really, really interesting case. A lesbian couple, through artificial insemination, had twins while they were together. The non-biological parent functioned as a parent to the twins, and then they broke up. And then the biological parent said, well, you're not going to have any visitation, and you're not going to have any custody over these children because I am the parent. I'm a biological parent, and therefore I have the right to decide how my children will be raised. And, it is true, as a general proposition, that there is a zone of autonomous privacy to parents. They get to decide who their children are going to meet with and how they're going to be educated, etc. However, in VC versus M.J.B., the court limbed the doctrine of psychological parenthood. That means that if you have served as a psychological parent to a child, even if you're not related to that child, you're going to stand in the shoes of a biological parent when the issue of custody and visitation has to be decided. And we established the requirements for psychological parenthood, and that was you had to live in the same home as the child, you had to function, carry out parental functions. The relationship between the third party and the child has to have been countenanced by the natural parent. I think those were the elements. Yeah. But essentially, psychological parenthood and things about it have emerged in other areas as well. Mm-hmm. But the important thing was to avoid harm to the child. And that was the leitmotif that basically ran through all the children's cases, at least the ones that I decided while I was on the court. And that was a subject that I was very interested in. Mm-hmm.
So do you think, in terms of how you would get assigned cases to write the opinions, it was a matter of what you expressed interest in or what you had prior interest in, prior experience in?
You mean on the Supreme Court?
Yes.
Okay, well, first of all, you have to be in the majority to be assigned the opinion. So if there's a split among the opinions that are being expressed by the justices, say 4-3, then somebody of those four, it has to be assigned the opinion. I would have to say that I got a lot of the family law opinions because they knew that I liked to write them. And honestly, other people didn't like to write them as much. And that was the same in the appellate division. I did a huge amount of family cases, again, because people were perfectly happy to have me assign them.
So going back to an issue we talked about earlier in light of the Netcong case, where it was very controversial, struck a lot of chords between what you might call the liberal and conservative spectrums of the political dial. Something like VC versus M.J.B. I got the letters right.
Yeah.
That was very controversial regarding rights for LGBT communities.
Yes.
Did you face any hate mail, any kind of backlash as a result of that?
No, not that I can recall. I don't believe that there was any backlash. But, you know, I had written an opinion in the Appellate Division of recognizing the doctrine of psychological parenthood. But, of course, we weren't the court of final resort in the Appellate Division. So I think that the ground had been laid for the notion. And it just really made sense in this context. So.
And, you know, a case like this is also where critics of the court will say, like, the court's being activist, that sort of thing. But, you know, what are your thoughts on that notion of activist judges or any kind of political aspect?
Look, in this case, this wasn't activism. This was the case that was before us. This was the case that we had to decide. And what it shows, I think, is that kind of spirit of progressivism of the court, ready to develop new remedies to deal with situations that nobody thought were ever going to occur in the past. I mean, I know Chief Justice Ports, I think, wrote a decision on splitting up the embryos when a family breaks down. Nobody would ever have thought that the court was going to have to deal with an issue like that. But what we did in VC versus M.J.B. was find a remedy for a situation that simply hadn't occurred before. Mm-hmm. But that judicial activism thing is something that people really, I think, most people don't really understand what the judicial function is. It is not judicial activism to enforce the provisions of the Constitution. The problem is that it feels anti-majoritarian to people who say, well, this is a democracy. I voted for Joe over there. He's my representative. He passed that law, and that's the end of it. But that is not the end of it. We're a constitutional democracy. The Constitution lays out the rights and responsibilities of our fellow citizens. And when a law is enacted that trenches on those rights, then it's not judicial activism for the court to step in. That's the core judicial function. That's exactly what we do. So when people say judicial activism, they look at an opinion and say, oh, look at those judicial activists. Sometimes they forget that we have no choice but to decide what is before us and to carry out the provisions of the Constitution.
And another case that kind of plays along those lines would be the Torricelli case, where people, again, claim that the court was leaning one way or the other.
Yeah, that was such an interesting case to me. That was not even a close case. First of all, the law, and I forget the amount of time that they said. Was it 52 days you had to be before an election in order to change the name on the ballot? That law was enacted at a time when it took 52 days to change the name on the ballot and to get the ballots out to the soldiers and to the people who had asked for absentee ballots. That's how long it took. We had the election officials in to the oral argument. They were parties in the case. And they told us they could do that overnight. So that notion, the full underpinning of the 52 days didn't even exist anymore at this point. And so what we were left with then was to look and see what had been decided previously. We looked at all the prior case law, and every single prior case basically said this: the most important thing that you can do is give voter choice. So that combination of things led us to the conclusion that they should be allowed to substitute the candidate. But the important thing at the end of that opinion, and Justice Ports wrote that, I believe, she said, and if we're wrong, tell us. But it's 18 years since this case was decided, and the legislature took no action whatsoever. So I'm going to presume that it was correct. I understand that the public said 52 days is 52 days. Well, Montesquieu said that too. He said, well, all you need to interpret a statute is your eyes. But that's not all, it just isn't always the case. And this was one of those classic cases in which it didn't quite work out that way.
Well, maybe we'll break from the cases, and if you could just talk a little bit more about, you mentioned it's a very collegial group, but also it seems like you really only discuss matters of law. The politics, other issues don't really come into it at all.
No, we are basically there to decide the cases. And we have, there's a pretty well-established decisional rationale that applies in every single case. And it is, politics doesn't play a part in it. Friendship doesn't play a part in it. The cases are decided on their merits. We try to adhere to precedent. And the reason we try to adhere to precedent is because if we just decided willy-nilly, oh, we're going to change this, or if every time a new justice came on the bench and it changed the vote in a case, the law would change, then there would be no way for the public and for lawyers to order their affairs. So we do try to adhere to precedent. But we don't always adhere to precedent. And if a really good reason is given to us why things should change, we do change it. Because, as a wag once said, precedent, or stare decisis, requires us to be as wrong today as we were yesterday. We do not trade votes. We don't say, oh, Justice so-and-so, if you vote for me in this case, I will vote with you in that case. Because then there would be no uniformity or predictability in our decision making. We try to effectuate the intentions of the legislature as much as possible because we respect the tripartite structure of our government. But again, as I say, it's not always that easy. And it's not that easy for a lot of reasons, two of which I can think of off the top of my head. The frailty of language. And there's an old cartoon, on that one, there's an old cartoon from the New Yorker. It has two panels. A yacht is sinking, and the yachtsman says to his dog, Lassie, get help. And in the second panel, Lassie is lying on her psychiatrist's couch. Now, that's the frailty of language. The second reason is the nature of the legislative process. Sometimes the legislature has to just leave something out because otherwise the law will not be passed. And they kind of leave it to the court to fill in the interstices. And sometimes they just haven't thought about the situation that has arisen. One example of that, I think, is that Smith versus Girone. A municipality had a fireworks display, and afterward everything was supposed to be picked up, and a child came into the park the next day, I think that's when it was, picked up a firework and eventually brought it home and blew his fingers off. The question was whether there could be a suit under the Tort Claims Act, which requires a dangerous condition of public property when the injury occurs. So, if you were to look at that literally, because the public property was no longer dangerous at the time that the injury occurred, there would be no ability to bring a case. But we held that the foreseeability of the injury should be taken into consideration, and we were satisfied that that met the intentions of the Tort Claims Act, if not the actual verbiage of the act. And that's why I say that Montesquieu and everybody else who says you just have to look at an act and that's all you need, they're not always right. We also try to be progressive, and that's what I mentioned about VC versus M.J.B. The court is always ready to modulate, to modify the remedies that it has previously limbed in order to meet new issues that it never foresaw. And that's pretty much the same in every single case. All of these decisional rationales come into play. Maybe not all of them in every case, but all of them are the guiding principles. And the most important guiding principle is the attempt to agree. Lots of really closely divided opinions are not that good, either for the public or for lawyers. It's better, really, if we could reach a consensus and we have mostly people agreeing. And that requires a lot of collegiality. It may require a justice to say, look, I'm not going to get my first opinion on this, but I can get my second, and we will all agree on the outcome. That's essential. I don't know how 7 people could decide what to have for lunch if there were not some sense of the need for collegiality, and they are the most collegial bunch that you've ever met, really.
So one of the areas where I think you wrote a number of dissents was the capital cases.
Yeah.
Can you tell me a little bit about your work in that field and your philosophy there?
Yeah. Well, I came open-minded to the Supreme Court on this subject in the sense that I had never had a capital case because capital cases don't go through the appellate division. And I'm going to confess to you, since most of the opinions, some of them were 500 pages long. I actually didn't spend a lot of time reading the jurisprudence because it was never going to affect me on the appellate division. So I had to start from scratch when I got to the Supreme Court. And the court, I cannot tell you, bent over backwards to try and get this area right, to try and work it so that everything would be as fair as possible. They developed methodologies. They used social scientists to do all kinds of work on it. And ultimately, I familiarized myself with it. And as I went through the cases, as we dealt with them, it just seemed clear to me that there was no way to guarantee proportionality in the imposition of the death penalty, and that there was a randomness or a freakishness in the way that it was applied that could not possibly, shouldn't stand. And I saw the cases again and again, and I didn't write because my nose was out of joint or because I wanted to hear myself talk. I wrote so that in the next case, the court might consider what I had said in the prior case, and maybe courts down the line would move into the position of the dissent. But what I found in in practically every case where proportionality review was involved is that there was no way to justify that everybody who perpetrated a gas station robbery and murder got 20 years, except for X, who got the death penalty. There was just no way to explain it. And so that continued to be an issue for me during the time that the death penalty was in effect. And I wrote a number of opinions. And I think it's really important to know that proportionality review issues don't involve just desserts. It isn't that this person, say Jesse Temendekwas, who killed Megan Kanka, that he doesn't deserve the death penalty as an abstract matter. The question that the court was delving into was when you look at Jesse Temendekwas against all of the cases in his cohort, was his penalty proportional to theirs? And so often I was asked, well, you mean to tell me you didn't think that Mr. Wakefield deserved the death penalty, or you didn't think that Mr. whoever deserved the death penalty? That was never the issue. The issue is whether it was randomly applied or freakishly applied, and that was what my conclusions basically were. And of course, there were death penalty cases where, for example, Ambrose Harris, his pretrial publicity was absolutely the worst that you could possibly imagine. And therefore, for me, I would not have imposed the death penalty simply because you could never get a truly fair jury under those circumstances. But those were very difficult cases, and the court wrote incredibly principled opinions. Hopefully my dissents were principled as well, and it was just a different way of looking at it. But ultimately the issue was taken out of our hands in 2007 when the death penalty was removed.
Now, I know a lot of the research, at least today, focuses on racial elements, that there's a disproportionate amount of African Americans who received the death penalty. Was that a factor at that point?
Well, yeah, and it was interesting. One of the issues that I actually had an issue with the court on is that the court said that in order to show a racial element in the imposition of the death penalty, the defendant had to relentlessly document it. That's a very, very high burden. My view was that any evidence that race played a role in it should be the end of the inquiry. And of course, you do have an inordinate number of African Americans still on death row. To me, now I'm the co-chair of the Conviction Review Committee that's studying unjust convictions. We're formulating a methodology for dealing with convictions in cases which it appears were improperly garnered. When we know from DNA how many mistakes have actually been made, people who have been on death row or been given life sentences, and we know from DNA that they were not the perpetrators, I mean, how on earth could we be reinstating the death penalty, which some people are actually discussing now?
Now, just, I'm obviously not a lawyer. I'm looking at it from an amateur perspective, but in reading through some of your opinions, there was one where, I think it was the Wakefield case, I may be wrong, you called for a moratorium on the death penalty. Is that unusual, or?
Well, I don't know if it was unusual, but we were in a kind of holding pattern at that point, and it seemed to me, I believe, that there was room for some study. I was not suggesting that all death penalty cases be reversed, but only let's hold on them until we can get a fix on things like in 87 in State versus Ramseur, the Supreme Court held the death penalty constitutional because it was in line with common morality of the day. I wasn't sure if it was still in accordance with common morality because of sociological studies that said that people were not as enthused about the death penalty as they had been. We couldn't answer that question, but we could study the question more. And that was all that I was interested in.
The Abbott v. Burke case series has been going on for many years, and it's become one of the most celebrated and controversial cases of the New Jersey Supreme Court. Mm-hmm. You were involved in several during your tenure. Yeah. What are your thoughts in general on the Abbott v. Burke series? Mm-hmm.
Well, I think the most important thought I have about it is that Abbott versus Burke is misinterpreted as judicial activism, when again, it is simply the exercising of the core judicial function. Our Constitution promises a thorough and efficient education to all children. The Abbott versus Burke cases are simply vehicles in order to carry out that constitutional promise. And I mean, I can't say any more than that. I recognize that people feel that we became too involved, if you want to call it, in the educational process, but there basically was no other way than to do that in order to guarantee the thorough and efficient education that our Constitution promises. And the same for Mount Laurel. Mm-hmm. Again, the Mount Laurel cases, there was all this hue and cry about activist judges, but again, the guarantee that people can live and work anywhere in the state of New Jersey and cannot be barred from doing so. It's part of our Constitution, and all that the Mount Laurel cases did was to make that guarantee into a reality. So they were two very good examples of where the public thinks we were engaged in activism when, again, we were only exercising that core judicial function.
So when you're looking at the Abbott v. Burke cases, how do you decide what's fair, essentially, for the students? Is it simply based on what's presented by the plaintiff? Yeah.
It's based on either that or it could be a special master. I know that we had Pat King was a special master in, he was a fabulous appellate division judge, retired in some of the cases. And so we had a full record before us on which to make the decisions. I mean, I know some people think that, oh, they just pulled this out of the sky, but that, of course, would not be the truth. We had full records, and if we didn't have a full record, we asked for a full record through, say, a special master.